I have another positive test from you that is not the result of a prescribed medication, what is going to end up happening is a motion to revoke is going to be filed. If the motion to revoke is in proper order, I am going to sign it. And once I sign it, a warrant will be issued for your arrest and you will be picked up wherever you may be. Are you Mr. Silva?
Yes.
All right, Mr. Silva, the reason why we're having this compliance hearing is because you have not been taking your urinalysis when you're supposed to take them. And when you have taken them, you have been positive. Do you understand?
Yes, that's what I've been told.
Well, I mean, you know, if you've done cocaine, alcohol, or marijuana.
Nothing. I'm not taking anything.
No, this is what the court has. On June 8th, 2023, you tested positive for alcohol. I'm sorry, you tested positive for alcohol on May 15th, 2023, May 23rd of 2023, May 31st of 2023, June 6th of 2023, and June 22nd, 2023. You are not allowed to drink alcohol while on probation. It does not matter if you're in your home, at the family cookout, at a restaurant, you are not allowed to drink alcohol while on probation. Do you understand?
I do understand.
That is the law. You are on probation. You cannot do the things that you normally would do, whether they're legal or not, while you're on probation. Do you understand?
I do understand what you're saying to me.
Then we have on June 29th, you tested positive for cocaine, alcohol, and marijuana. Then July 6, 2023, you tested positive for opiates, marijuana, and cocaine. You are not allowed to use drugs while on probation in this court. And the drugs that you're testing positive for are illegal. With regards to the marijuana, if you're using marijuana without a medical reason for using it that has been presented to probation, you're violating your probation. Do you understand?
I do understand.
Now, I understand that you tested negative on April 27, 2023, May 1st, 2023, May 8th, 2023, June 15th, 2023, July 13th, 2023, and July 20th, 2023. Now, I'm reading that you are the provider for your wife and your children. If I have another positive test from you that is not the result of a prescribed medication, what is going to end up happening is a motion to revoke is going to be filed. If the motion to revoke is in proper order, I am going to sign it. And once I sign it, a warrant will be issued for your arrest and you will be picked up wherever you may be. If you're at your employment, they're going to arrest you at your employment. If you're at your home, they're going to arrest you at your home. If you are in pickup line to pick up your children, they will arrest you in the pickup line and they will call someone to come pick up your children, be it your wife or a relative or Child Protective Services. Do you understand?
I do understand.
If a motion to revoke is filed, and if I find it true, you are looking to join up to 10 years in prison. I'm not saying you will be sent to prison for 10 years, but what I am saying is that is in the realm of possibility. Do you understand?
I do understand.
So From here on out, everything you do, there are two questions you need to ask yourself. One, is what I'm doing, could it potentially result in me going to prison for 10 years? If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand?
I do understand.
Now, they were recommending that you go to inpatient treatment. He has tested negative today. So I'm not looking at placing him into inpatient treatment today. Probation, what are your thoughts?
Your Honor, I think possibly, he's currently in the intensive outpatient program. I believe he has like 2, maybe 3 weeks left of that. Possibly a drug patch.
Okay. All right, I'm gonna alter and amend for a drug patch or the UA hotline, and that will be until further notice.
He is currently, Your Honor, I just want to point out, taking weekly UAs.
Okay. All right, so does probation want both the drug patch and the UAs?
We can stick with the weekly UAs, Your Honor.
All right.
And you've already explained if he tests positive again to file an MTR.
All right, so if you could speak to him and find out which is cost effective for him, the weekly UAs or the drug patch.
Okay.
What type of work do you do?
In construction,
The patch may not be best for him. All right, so the patch may not be best for you because you're working in construction and it's 105 degrees sometime, and there may be some issues with the patch. So we'll continue with the weekly UAs, but I want him on the UA hotline, and he's the test weekly. And make sure they're testing for alcohol.
Yes, Your Honor.
Is there anything you need from the court?
Pues me han dicho que probablemente salían positivos porque tenía diabetes, pero no sé, yo nunca me he chequeado.
well, they told me that maybe I was coming out positive because I had diabetes, but I've never checked that.
All right, diabetes. The last time I checked, having diabetes will not give a positive UA for cocaine.
Porque pues ya van varias que me han salido positivos, pero yo no he hecho nada, la verdad.
It's
Yo
just
no sé
that,
por qué
that
han salido positivos.
I've had several positive tests and I haven't done anything, so I don't know why they're coming out positive.
All right, here's what I know. And if I'm wrong, I am open to being corrected. If you have diabetes, you will not test positive for cocaine. You will not test positive for marijuana. Now, mind
Okay.
you, that's the last time I checked. If there's somebody who has some study that will show that if you have diabetes, you can test positive for cocaine, you can test positive for opiates, you can test positive for marijuana, show it to me, and I will apologize. But so far, I haven't seen any studies that says that. You understand?
Yes.
All right, so again, is there anything that you have not been given by probation that you feel you need that would help you be successful on this probation?
No,
No, well, that's all.
yo estoy siguiendo las órdenes que me dieron.
I'm following the orders that I was given.
All right, probation, is there anything else?
No, Your Honor.
All right, probation will go over your amended conditions with. All right, the court is in receipt of a motion to modify full house arrest. State, have you had a chance to review the motion?
Previously, we did, yes.
All right, are you in agreement with the motion?
No, we're not, Your Honor.
All right, defense, do you have any witnesses?
I do, Your Honor. I have, so we're really asking for two things. We're asking that she be allowed to pick up and drop off her children from school. And then additionally, we're asking that she be allowed to participate in outpatient alcohol treatment. We have the outpatient alcohol treatment provider here. We'd like to call him as a witness if we could.
Okay, all right, you can call whatever witness you'd like to call. All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record.
My name is Richard Paul Green III.
All right, defense.
Tell us a little bit about yourself. What do you do for a living?
I am a licensed therapist specializing in chemical dependency counseling. I'm the CEO of Precision Recovery in
All
San
right,
Antonio.
and just not to interrupt, but I'm aware of who the gentleman is. So if you want to
Can you
move past that, you
Sure.
can. If not, state if you want him to go into his credentials, you can.
That's all right.
All right,
Thank you, Your Honor. Can you describe the program, just briefly what we're here for? Ms. Schnitz is on full house arrest, and I'm asking, really, what we're all asking is how can she participate, or what kind of supervision does she need to participate in your program? And can you describe the program to the court that she has signed up for?
Yes, I can do so. Ms. Schmitz has voluntarily entered the Precision Recovery long-term treatment and monitoring program, specifically for felony DWI defendants. It's a long-term medically integrated program, which lasts 3 to 5 years. She will start with an intensive outpatient level of care, possibly partial hospitalization level of care, and then move through the program where she will see a professional at least at a minimum of once a week for the next 3 to 5 years.
Is this something that she can do? So is it more effective to be in person for those meetings or remote?
We do like to see our patients in person. We find it to be much more accurate. The monitoring part of the program is very intense. It's built on the modeled after the physician's health program and the airline pilot's HIMSS program. So it's a very high level of monitoring, and we really need to see people in person.
If the court made participating in your program a condition of bond, and Ms. Schnitz were to not complete the program, stop going, or begin using substances that were prohibited, would you be able to report that to pretrial and to the court?
We could and would report that to the court.
And what kind of monitoring can you provide in addition to right now she's on scrim and she's on the ignition interlock device?
So we would add to that LCMS urine drug screens weekly, randomly. We would also add a heart rate variability monitor to be worn 24/7. That shows us when there's issues with heart rate variability that the client or patient is under stress and maybe at risk of relapse. She would be on remote treatment monitoring, where we'd have our call center ready to call her. They would contact her 3 times a month regardless, but in case there's any issue. We'd be using a medical compliance device called by GeriSafe called MediTrust. That machine videotapes her compliance with her medication. She's already been prescribed naltrexone. When she's on the right therapeutic dose for naltrexone, and we'll be measuring that through laboratory tests to make sure it's at the right level. She won't get any reinforcing effects from alcohol if she did relapse on alcohol, and it will blunt the reinforcing effects of other substances as well. We'll be using a recovery app that is designed for the therapeutic courts, called Reconnect, where we can tell where she is 24/7. We can geofence her out of areas should the court or her treatment team decide to do so. We also can know whether she's attending her AA meetings, which is very important. We really strongly recommend she be present to an AA meeting at least twice a week. We can tell whether she's on time, whether she left early, and whether she's contacting people in her support group, including her Alcoholics Anonymous sponsor. That's just some of the monitoring we do. There's more than that, including outcome testing regularly.
And so could you just describe for the court what she needs to leave her house to participate in?
So she would need to leave her house to participate in Thursday night groups where we can run urinalysis weekly and check in for outcomes and for other signs and symptoms of any type of issue that would lead towards relapse. Any for lack of a better term, disruption in emotional sobriety. Beginning September 18th, the plan is to bring her into a partial hospitalization group where she would be at our clinic from 9 a.m. till 5 p.m. So she needs some travel time in there. So probably from 8:30 at least till 6. Then after that, she'll be at a level of care of intensive outpatient where we'll be seeing her Monday, Wednesday, and Thursday from 6 p.m. to 9 p.m. for 12 weeks. After that, we'll be seeing her on Mondays and Thursdays from 6 p.m. to 7:30 p.m. in what's called supportive outpatient. She will be have physician appointments with our physician, with our addiction medicine physician too. That schedule, I don't know at this time. He would like to see her at least one time in person, and the rest can probably be handled through video.
And can you provide these schedules to missionaries who could then provide them to pretrial in advance?
Yes, absolutely.
I have no further questions. I'll pass it.
So this program is, what type of substance is the person addicted to?
They can be addicted to anything. Most of our patients have alcohol use disorder.
So they have to admit they have an alcohol dependency, particularly in this case.
Admit?
Yeah.
Well, yes, they come around to it eventually.
Okay.
Yeah, there's
There's
denial is usually there.
Yeah, I'm
more
not trying to
often
get
than
into all the clinical things.
Yeah, yeah.
But I mean, this program is, especially in this particular case of this client of yours, it's an alcohol dependency that she has.
We don't use the term dependency anymore. We say alcohol use disorder.
Okay, I mean, change
Yeah.
the name, but it's the same thing, right?
Yeah.
Okay, and in this particular case, so do y'all make reports? What do y'all do? Do y'all make written findings?
We can do whatever the court would like. Usually for pretrial, we provide what that pretrial officer wants. Same thing with probation.
So, I mean, anything's discussed, it can be in a report that's sent to the judge.
Yes, anything that's relevant to the public safety or the compliance of the patient with the program.
No further questions.
Nothing further, Your Honor.
All right, I have a question. Any objections to the court asking questions?
No objection from the state, Your Honor.
No objection, Your Honor.
So you're able to do these meetings by Zoom?
We do have the capability. We'd rather not do anything other than medical follow-ups through Zoom. We definitely would like to have the first medical assessment in person. There's just certain things we need to be able to do, like palpitate the liver, et cetera, and look for physiological issues that are actually hands-on. We'd prefer to see all our patients in person. We've used Zoom in the past, and it's our belief that in person is much more effective.
All right, so the only thing that you may not be able to use, well, you do not use Zoom for, is for medical testing.
We cannot use Zoom for medical testing.
Okay.
Or laboratory testing.
I just wanted to
Yeah.
make sure.
Yeah, we can't, we have not found a way to use laboratory testing or urine drug screens or quantitative EEGs, many different medical interventions we cannot use remotely.
Okay. All right, any other questions?
Just to follow up, Alcoholics Anonymous in a remote setting, is it as effective in a remote setting as it is in person?
In my opinion, no. It really takes being there, being in the moment and sitting with people who can relate to who you are. But Alcoholics Anonymous is very important for treatment. And there was a great meta-analysis that was published in 2020 that shows that it may be the only thing that maintains long-term sobriety. And I can provide that study for the court if you'd like to see.
I've read it. Yeah.
Thank you.
Yes,
I appreciate
I
that.
always try to keep up on all things treatment and anything really to do with the legal system. Thank you.
I really appreciate that.
Oh, you're welcome. I try. All right, thank you. Is there anything else?
Your Honor, just argument, I suppose.
All right, thank you.
Thank you.
I would like to ask your client a couple of questions. Is there any objection?
Well, Your Honor,
Because there are things that I need to know.
okay, and
And if I don't know them,
I understand.
then
I understand. I guess we'll see what the question.
All right, can you raise your right hand for me?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Shelley Schnitz,
All right, how many children do you have?
3.
What are their ages?
I have a 22-year-old son with severe special needs, quadriplegic. I have a 15-year-old daughter, and I have a 6-year-old daughter.
All right. So who helps you with your children?
Patrick, who is my boyfriend. We've known each other for the past 10 years. He helps me, my family helps me, my mother and father, as well as some other supports.
Are they all here in Bear County? All right, so who's here in Bear County that helps you?
Patrick.
Okay. And what are the school hours for the 6-year-old? Does the 6-year-old take the bus or no?
No, ma'am, we live exactly 1 mile from the school, which is Wilderness Oak Elementary. And so we cannot obtain the bus permission for her to ride the bus because we're too close. So she has to be taken to school every morning. Drop off is between 7 and the tardy bell rings by 7:25. And then pickup is in the afternoon. The bell rings at 2:45 to start pickup. And then it just depends on how many cars and things are there to go through the line.
All right, and your 15-year-old, does the 15-year-old take the bus?
No, ma'am, she's at Reagan High School.
Mhm.
And she, their time is 8:30 to 9 to get to school. And the time that she gets out is 4:30 to 5.
So you do drop off with her?
Yes, I have split custody with her father, and we do that.
So if I were to allow you to do this thing at the clinic, how are you planning on taking the 15-year-old to school? Because the person testified that it's from 8:30 to 8:30 a.m. to 6 p.m. So who's going to be taking the 9-year-old? I'm sorry, the 15-year-old,
I
if I were to allow that.
I can make arrangements on the special days, Your Honor.
And Your Honor,
No. Still asking questions. So what would be your arrangements for the 15-year-old during that time?
I would probably ask one of the moms that's a friend of hers that has a child that goes to that school that I'm friends with, or something like that, just on a very short-term situation.
All right, any other questions?
Help you say, John.
you also take her early.
Oh, yes, sir. I'm sorry. I didn't think of that. Yes, sir. I absolutely could do that.
Usually if you can get, you can get them anytime after 8,
Oh, sure. Yes.
and that would allow you enough time to.
Yes, I'm sorry. Yes.
All right. Anything else from either side?
Nothing from the state.
All right, the court will hear argument.
Your Honor, we're hoping that you allow her to drop off and pick up her kids from school, obviously. I think the court's investigated that. I think it's.
All right, so let's stop right there. State, do you have any objection with her being able to drop off her children?
Your Honor, just the severity of the allegations in the indictment, it's I believe a 14 count indictment of intox manslaughter, intox assault, aggravated assault, failure to stop an underage, causing a death, and failure to stop an underage, causing injury. The state would just be opposed to her driving it out.
Okay. And are you currently, well, I'm assuming she's currently driving.
No, ma'am.
She's on full house arrest, Your Honor. So to do the urinalysis, for example.
Well, no. So if she's on full house arrest, then we were here last time where the court allowed her to attend parenting night. How did she do that?
Because we got specific.
No, I mean, we got permission, but how did she get to parenting?
Patrick was able to take me because it was after his work hours.
Okay, all
But-
right.
I'm sorry.
No, go ahead.
Do you mind if I say one more thing?
No.
Because of his work hours, he has a position at Southwest Research, which is entirely across town from our home and area. And he goes in early and he works later. So he could not manage to not be late to drop her off or not be late to work and also to pick her up because of his time involvement with work and the consideration with traffic and him driving across town. So that would leave me as the option to take and pick up.
All right, State, do you have any objections with her going if she's not driving?
No.
All right, that's what B is for.
There would be no way to take a bus. There's no bus in my area.
Mhm.
It would not, the school is 1 mile from my house.
Mhm.
And also, Your Honor, I have not been driving for over 5.5 months.
Mhm.
I have been to 30 days of full inpatient rehabilitation, which I was very successful at.
That's
Um,
30 days.
But Your Honor, I'm sorry. May I-
No,
Okay.
you can
Then I
continue.
also did a 12-week intensive outpatient program as well. And I have been perfectly I have not had any issues after that with any testing, with anything else in that time, Your Honor. And I am very committed to my sobriety and staying clean and doing the right thing, Your Honor. That is the most important thing, and my family. And if I have to pay for transportation currently on an Uber or a Lyft, because I do not have any family or anyone else that may take me. And Your Honor, that is costing me $900 a month. And Your Honor, I have come to the limits of my financial situation. I have no retirement. I have no savings. But I'm trying very hard, but financially, I cannot afford that. I'm sorry. Thank you.
No, there's no need to apologize. I want to hear what your circumstances are so I can make an informed decision. I always tell people, if there is something I'm saying, but you want to respond to it, please respond to it, because if you're quiet, guess what? I don't know. So I appreciate you telling me what your financial circumstances are. Okay. All right. Anything else from the defense of the state?
Your Honor, as far as the treatment goes, I do think that it's important that you go in person. I will tell you, Your Honor, being on full house arrest with sole custody of a child, she's probably one of the loneliest people that you will see in your court. Being a part of a group of Alcoholics Anonymous is going to be a tremendous help to her. Being part of a recovery community that was described by Mr. Green is also going to be a tremendous help to her. So we would ask that she be allowed to do those things in person as part of her recovery and pretrial release.
All right. So it's the court's understanding, and correct me if I'm wrong, State, you have no objections with her attending treatment, no objections with her doing drop off, but you do not want her driving.
That's correct, Judge.
All right. So the court will allow you to attend all the treatment. The court will allow you to drop off and pick up your children, but you are not allowed to drive. Is there anything else?
Nothing from the state.
Can we, Your Honor, then get the ignition interlock device removed from her vehicle, because she's gonna have to give up. Right now, she
It
has
to go back.
All right. If you file the motion, the court will hear it.
a separate hearing on that, Your Honor,
Pardon?
a separate hearing on
Yes.
that.
So I'll allow you to attend all medical appointments, all treatment appointments. All school functions. And I consider, when I say school function, I consider dropping your children off to school, picking your children up, going to their extracurricular activities. So all school functions,
Your
but
Honor.
there's to be no driving.
Your Honor, may I ask one question?
Sure.
May I walk to school? to get
Yes.
her?
Yes, you can walk,
Or ride a bike?
just no driving.
Yes, ma'am.
State, do you have any objection to her riding a bicycle?
I can just walk. I don't have to ride a
No
bicycle.
objection to a bike, just as long as she's following the traffic laws around.
Okay. All right. Is there anything else?
Nothing further, Your Honor.
All right, thank you.
Thank you. May we be excused?
Yes. Who's here on Sean Griffin?
I'm Your Honor.
All right, Mr. Griffin, if you'll come forward.
But Judge, he's actually out in the hallway.
Oh,
Can we
haven't,
get him?
yes. And then after Sean Griffin, it's going to be Roberto Maldonado, Carrie Henderson, and Elsa Morales.
Or Maldonado, Judge, he said COVID.
All right, just give us a moment. You say Maldonado? Come on forward.
I've got, he's got home test, Judge. His mom had it last week.
Okay.
So we're just asking for a week or two to get him in.
Norma, can we call this at the end of the month?
Very first.
All right, we'll see you August 31st.
Yes, ma'am, thank you.
All right, thank you. Did I tell people there's an outbreak of COVID?
Yes, Judge.
All right, who's the party, you're on that side, who's the party on Sean Griffin for the state?
Travis, thanks for the state of Texas.
All right, so where are we on this case?
Judge, we received an offer. I still need to keep going through discovery, but have some discovery issues on this one as well.
What are the discovery issues?
That it did not download this afternoon, or not this afternoon, this weekend. So I've gone through a lot of it, but to get the entire aspect of it, go through all the body camera after we download everything.
All right, are there any CPS issues in this case?
No, Judge.
Okay, so Child Protective Services was never called out?
No.
State, were you able to tender an offer or no?
Yes, Judge.
Okay,
And we are considering it, Your Honor.
I'm sorry, what?
We're considering it. I
Okay,
need some time for that as well.
all right, Ms. Ferguson, can I have a 30-day reset on this case for a plea deadline date?
Yes, September 18th.
All right, September 18th is your plea deadline
And
date.
Judge, we would like to ask, he has GPS on, he is a licensed barber, a traveling barber. I've talked to the state about it. There haven't been any issues since this event. If we could do tracking only.
All right, file a motion and the court will consider it.
Okay, thank you, Judge.
You're welcome. Who's here on Carrie Henderson?
I am
All right, this is no application.
That's correct, Your Honor.
Court is calling 2022 CR 10916, State of Texas versus Carrie L. Henderson. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense,
Todd Lester for Mr. Henderson.
are you Mr. Henderson?
Yes, ma'am.
Counsel, you received all the discovery and did you review it with your client?
I have, Your Honor, and I have.
Court will find that the state is in compliance with discovery. Mr. Henderson, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Henderson, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
No, ma'am. Yes, ma'am. Yes, ma'am. Sorry.
All right. Did you intend to give up those rights?
Yes, ma'am.
Did you intend to enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Henderson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 1 year in the state jail facility. There are no applications. The state will take in consideration GJ grand jury number 803-269, JN21366760, night mag number 7145598. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
State offers State Exhibit 1 in all attachments.
Any objections?
No objections.
State, you may be excused. Mr. Henderson, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this, don't use her thing as your desk. Yeah, that's her office. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
I'm 41.
All right, you're 41 years old. Are your parents still in your life?
Yes, ma'am.
And how old is your mom?
She about to be 60.
All right. Does your mom love you?
Yes, ma'am.
You're breaking her heart.
That's what I'm trying to get this passed so I can get back to her.
So, but when you say get it past you, you've got to work on it.
Mhm.
You got to stop using drugs, because otherwise what will end up happening is drugs damage your body inside and outside. You don't want to be that person where there's somebody found dead in San Antonio and people trying to identify the body, and your mom learns on social media that it's you. Because the last time you use could be the last time you use. When you go into custody, nobody likes being in custody. And they always say, when I get out, I'm never going to do this again. But then the first thing they get out, maybe they're good for a couple of days, maybe not. Maybe they say, ooh, I'm celebrating, I'm out. The first thing you need to do is go to AA meetings or NA meetings. And if there's anybody in your life who are trying to stop you from going to AA or NA meetings saying, well, you don't have to go today. Let's play some dominoes. You don't have to go today. Let's go hang out at the park. You need to cut them loose, because the number one thing.
The courtroom started with an unusual mix of humor and strict warnings. The judge called out names one by one and made it clear that anyone who failed to respond could face a warrant. She then explained the courtroom rules in detail, warning attorneys and visitors not to touch staff desks or create unnecessary noise. At one point, she joked that if someone treated a staff member's desk like their own office, she would visit their office and do the same. The courtroom laughed, but everyone understood she was serious about maintaining order. As the hearings continued, one defense attorney admitted that he still needed time to review video evidence with his client before accepting any plea deal. The judge listened carefully, confirmed there were no missing discovery materials, and scheduled a new plea deadline. She clearly told the defendant that the next court date would require a final decision on whether the state's offer would be accepted. The exchange was calm, professional, and showed how closely the court monitors every step of a criminal case. Later, the mood in the courtroom became much more serious during a probation compliance hearing. The judge reviewed a long list of failed drug and alcohol tests, including positive results for alcohol, cocaine, marijuana, and opiates. She firmly reminded the defendant that probation comes with strict conditions and that even legal activities like drinking alcohol are prohibited while under supervision. The judge repeatedly asked if he understood the seriousness of the violations, and the defendant quietly responded that he did. The tense exchange left the courtroom silent and highlighted how quickly probation violations can place someone back in danger of harsher punishment.